This is how I read your brief. I want to be fair in characterizing it. The way I read your brief is that you're basically arguing, unless the state introduces a lab report, they can't meet their burden.
Not exactly, Your Honor. I will say that when an element of the offense is the existence of unlawful cannabis, a lab report is the most straightforward way to show THC concentration. The state has to show THC concentration to show that the cannabis is unlawful. I would say, though, I would not foreclose any possibility of circumstantial proof. For example, unlike in this case where...
Well, a presumptive test that the officer testified he's run 40 times, or whatever the number was, or something like that, and he's never had it come back as not being positive for illegal cannabis, illegal marijuana.
Oh, first, Your Honor...
Surrounding all the other events.
Sure.
I mean,
certainly.
I would probably agree with you. If that's the only testimony the state presented, that may not be sufficient. But we have some other things here. So we can prove it circumstantially.
I do not dispute that it can be proved circumstantially, and some of the cases cited by my friend illustrate that point, but those cases are highly distinguishable. But first I'll talk about the special agent's testimony, because you brought that up.
Yep.
And I think looking at the entire context of his testimony, here's one thing that the court should keep in mind. He testified that he could not confirm that this was a controlled substance. He testified that by the TBI's own standards, the only testing that was requested of him was presumptive testing, which is insufficient, again, by the TBI's own standards, to confirm that this substance was unlawful cannabis. And so that just
But he
shows...
testified to more than that, though. Too. I mean, I agree with you that
Correct.
he said, but he also then clarified, however you want to say it, that he's run this presumptive test not just once or twice, but numerous times, and every time he's run the presumptive test and then run the actual test, they match.
Your Honor, I don't think his testimony is quite that clear. He guesstimated that about 40 times in the past, he had run testing and it had come back as presumptive marijuana. That is just not consistent. First of all, that proves nothing about the cannabis that was possessed by Mr. Jones. This could have been cannabis from any part of the state that he tested. The TBI does testing all over the state. He did not test this cannabis multiple times.
No, I recognize. I'm just saying he's used the presumptive test numerous times.
A guesstimate of 40 past cases led him to say that, yes, I've done testing in the past and it came back as presumptive. It's not even clear what kind of testing he did in those 40 cases. So it's not to say, that says nothing about the cannabis in this case. The relevance of that testimony is frankly even questionable. What does a guesstimate, that's his word, a guesstimate of 40 past cases tell us about this plant material that was possessed by Mr. Jones in this case? It really tells us nothing. Now, I'll stick with sufficiency.
I know you probably want to talk about the stop, but let's talk about the sufficiency since we're on it.
And so the element that has to be proved is that the THC has that the cannabis has a THC concentration of greater than 0.3% on a dry weight basis. And so there are no Tennessee cases directly on point, at least none has been cited in the briefing. The only cases that have been cited that are directly on point come from the Indiana Court of Appeals, which has addressed this issue, this exact same issue, in a series of cases dating back to 2022. That's the Fegid case and the Ivy case, Toledo Rojo, several others. And what those cases uniformly say is this: when the only way to tell the difference between lawful cannabis and unlawful cannabis is THC concentration, then there has to be some proof as to THC concentration. Here, there was none. And I think...
Well, there is, though. There's the presumptive test. I mean, you know, I understand your argument, but to prove possession of marijuana, you have to, the elements are just possession of illegal marijuana, correct?
In the definition of marijuana.
I know, but that's in the definition. So we're looking at the elements.
The elements
okay?
of marijuana, correct.
So I don't have to, quote unquote, technically, that's why I say you don't have to introduce a lab report to show it, because you can prove it's illegal marijuana other ways other than just a lab report.
Correct, Your Honor, and the state failed to do so in this case.
Well, okay, but what the state has is a pretty good circumstantial case. They have your client asleep at a light. It takes the officer not just honking his horn, not just pulling it behind him, turning his lights on, not just turning his siren on, but literally going up to the window and pounding it with his flashlight and screaming at him to wake him up. You have your client, and I know we're going to get into another debate right here, but saying, yes, I smoked weed. What weed means, I understand your argument there, but saying he smoked weed, the mom on the phone saying, just tell him you smoked weed. And then you have digital scales, baggies, and $729 in cash, along with a presumptive test for marijuana. That seems a pretty good circumstantial case that what is in that car is illegal marijuana.
What I don't dispute are any of the individual facts that Your Honor has stated, but none of those facts indicate that the cannabis possessed by Mr. Jones had any THC concentration. Presumptive testing does not test for THC concentration. It just doesn't test for that. It tests the ratio of THC to CBD, but it does not tell you at all what you need to know to distinguish lawful cannabis from unlawful cannabis, which is THC concentration. Moreover, the state could have done that testing in this case. It met the TBI's
I'm not saying this is a
standards.
perfectly tried case. I'm just saying
Well,
there's some circumstantial proof here.
And it is not my intention to just criticize that. I just want to say, frequently, if you encounter things that you might ask, how could this be proved? And in that situation, it leads you to look at a more permissive view of circumstantial evidence, such as with intent. We typically don't have a declaration of intent or a view into the mind of a defendant. So we look at a lot of circumstantial proof when it comes to intent in criminal cases. But this is a scientific fact that is readily provable. They could have done this test. Moreover, Your Honor, there's no proof that Mr. Jones was aware of the THC concentration of this cannabis. And so the presence of scales, for example, there's no proof in the record suggesting that the presence of scales makes it more likely that cannabis has a THC concentration exceeding 0.3%. This is just a very specific scientific fact that must be proved. And I think that the cases cited by the state actually support our position here. So if you look at, for example, the case of State versus Shutt, in that case, this court held, in an opinion by presiding Judge McMullen, that, to your point, Judge Dyer, there can be circumstantial evidence as to a substance that can suffice in the absence of a lab report. But if you look at that case, the controlled substance was hydrocodone. And you had the state supplying extensive expert testimony that hydrocodone has visual markers that are intentionally put in place by the pharmaceutical companies because, for obvious reasons, we don't want hydrocodone to look the same as aspirin. And so you had imprinted numbers on each pill. You had a specific shape to the pill. You had special edging and indentations that an expert can look at and say with a high degree of certainty, this is a controlled substance. I can confirm, I can testify with a high degree of certainty that this is a controlled substance. So what did you have in that case? You had observational methods that were sufficient to establish that the substance was what it needed to be unlawful. Here, quite the opposite.
But the observational methods would rely on circumstantial proof, right?
Correct.
Same thing Judge Dyer was asking you about, if you agree with the state. I know you don't, but that's circumstantial proof too,
Not in my
right?
job description, in fact.
Right.
But the contrast is clear, because in this case, whereas in that case you said you had an expert saying, I can look at this pill and I can testify with certainty that it's hydrocodone. Here, what was the expert proof? I cannot tell you that this is marijuana, as that term is defined in the criminal code. I cannot confirm that this is unlawful cannabis. I have not used any methods that would distinguish this cannabis as unlawful as opposed to lawful. So the testimony is in stark contrast from Shutt. The testimony in State versus Signer is also in stark contrast. In that case, the controlled substance was marijuana. But there's a key fact about that case that the state neglected to mention. The events of that case took place before the change in the law. And so in that case, the expert was simply able to run tests and say, this is cannabis, and cannabis is unlawful. And so that leads to the conclusion that it was necessarily the controlled substance that the state purported it to be.
How would Lieutenant White's testimony, I guess,
Of
go
the
into the
scales and
circumstantial analysis here? I mean, he testified as a drug identification expert, basically gave opinion testimony, right?
Correct, and he said that he could not tell the difference between unlawful cannabis and lawful cannabis based on any observational method.
But he talked about the packaging, and I think he talked about of an illegal substance and how it supported that, right?
Yes, and what he said there is very important, Your Honor, and this is one of those instances where I think we have to really look at what he said. I know that testimony doesn't need to be read like a statute all the time, but what he said was that an individual who possesses a narcotic, and he also possesses scales and baggies and cash, is likely involved in the trafficking of narcotics. But what did he condition his statement upon? The possession of a narcotic. In other words, a controlled substance. In other words, if an individual possesses a controlled substance and then has all this other stuff, then he's probably selling it. We don't dispute that. But the very thing they failed to prove was that he had a narcotic. And so that officer's testimony is expressly conditioned upon the possession of a narcotic. In other words, if you have a narcotic and you have scales, then you're probably using those
Well,
scales.
but you can read it the other way, though. If you have all these things and something that smells like, looks like, presumptively is a narcotic, then it's a narcotic.
It also smells like and presumptively is lawful cannabis. So we just don't know. To this day, we don't know. The testing has not been run to tell us whether this is lawful cannabis or unlawful cannabis. And unlike things like intent and so forth, this is a pretty cut and dried scientific fact. And so it's more difficult to use circumstantial evidence to prove it. This court should follow the very common sense logical argument of or rather holding of the Indiana Supreme Court, rather the Indiana Court of Appeals, and hold that the state does have to prove THC concentration when that is the only way to distinguish lawful cannabis from unlawful cannabis. I'll just touch briefly on the suppression issue during my remaining time. So during the pendency of this appeal, you'll notice the case State versus Green was not cited in my principal brief. That's because it did not exist at that time. That case was decided during the pendency of this appeal. Of course, in that case, we learned, or maybe you didn't learn, I learned, that the odor of cannabis alone is not sufficient to establish probable cause for the search of an automobile. Instead, the court will look to the totality of the circumstances, and when you do have some detection of odor, sort of a logical starting place, that's, I believe, the analysis in Green supports that, and then the court looked at whether there were additional facts making it more likely that the cannabis would be unlawful as opposed to lawful. And in Green, the court found that was the case because the defendant and his compatriot gave evasive answers to the officer's questions. They gave answers suggesting that they knew that what they had in the car in their backpack was contraband, and there was some evidence of an air freshener or something of that sort to mask the odor. And so you had evasive conduct, you had masking conduct, and those things made it more likely that the cannabis in the vehicle was unlawful as opposed to lawful. Here, I would submit that you don't see any such facts. There are additional facts, to be sure, and my friend will talk about them, but those facts merely tell you over and over again that this car likely contained cannabis. They don't tell you that that cannabis was more likely unlawful than lawful.
But the law doesn't say that if the officer can't tell the difference between legal or illegal cannabis, that if it ends up being legal, that all of a sudden anything else they may have found, like I said, they found a gun or whatever else in the car, has to be suppressed, because it is, look, he smelled it, he had all these other things that gave him probable cause to search the vehicle or whatever the case may be. Now, when we come back and finally test the substance and find out it's not marijuana, doesn't eliminate the search because he had all these other things at that time, the probable cause at that time. correct?
I think I understand your point, Your Honor, but my point is that those other things did not make it any likelier that this cannabis was unlawful. And I can tick through them briefly. A firearm. A firearm does not make it more likely that someone has unlawful cannabis as opposed to lawful cannabis. This court has held that a firearm is not even sufficient for reasonable suspicion when it is apparently lawful. Being asleep at the wheel of a car. We have cited a clinical study showing that CBD, lawful CBD, in fact, causes people to fall asleep. So that does not make it any more likely. You can apply the same thing with each of the additional facts referred to by the state. And
If you take them individually, and the question is, what if you put them all together?
Yeah, the
if you put them
totality.
all together, you do start, I will admit that there was probable cause to believe that this car contained cannabis. And then you have all these other facts that also show that the car likely contained cannabis, but none of them show that it was unlawful. And so when you add 0 plus 0 plus 0 plus 0, what you get is 0.
But, okay, I mean, I think, I think the case, the Supreme Court's most recent case, it makes it very clear that it is a totality of the circumstances review. And that's what I'm asking, what Judge Campbell is asking. It's not looking at, his comment, I smoked weed,
Sure.
in a silo. And it's not looking at the officer saying, when I opened the window, whew, it hit me like a ton of bricks, or, in a silo. It's all these things together. And my point that I was making is, you have all these things together. Yes, at the end of the day, maybe it ends up being legal cannabis. But at the time, based on everything that officer knew, did he have the right and probable cause based on the totality of the circumstances of what he knew at the time? That's the question. It may end up later not being legal, but at that time, based on everything, he did.
Certainly appreciate that point. If I can just briefly conclude.
Yeah, please.
Absolutely acknowledge that it must be looked at in the aggregate. Our position, I can only talk about facts one at a time though, so I have no way of talking about them all at the same time. But when each of the facts don't show anything to suggest that the cannabis is more likely unlawful, then even in the aggregate, you still get to the point where you started, which is that the car likely had cannabis and we don't know whether it was lawful or unlawful. For both of those reasons, the suppression and the insufficiency, we ask that this court vacate Mr. Jones' convictions. Thank you.
Thank you, Counselor.
Good morning, Your Honors. May it please the court, Davey Douglas on behalf of the state. This court should affirm the judgments of the trial court because officers had probable cause to search the defendant's vehicle, and the evidence is sufficient to show that the substance he possessed was marijuana. And I'd like to address the issues in the same order as the defendant, but I do need to unfortunately start by acknowledging a typo in my brief that my friend on the other side pointed out. There's some references to a Lieutenant Green. Lieutenant Green does not exist. It's Lieutenant White. In drafting this, there was a lot of research into this case of State versus Andre Green, references to green lights. They're both colors. My brain mixed it up, and I didn't catch it until my friend on the other side did. So
I thought it was the color of the cannabis.
that too, Your Honor.
We'll forgive you this time.
Thank you. I very much appreciate your grace there. But the information that was known to Lieutenant White and Officer McLean was enough to create probable cause to search the car here, and then there was enough proof to show that the substance was in fact marijuana. Judge Dyer, as you alluded to in your questioning, the state is not required to introduce a lab report or a chemical test to show that a substance is marijuana. The presumptive test from Special Agent Depew and the other circumstances surrounding the discovery of the marijuana here, that's sufficient evidence to show that it is indeed marijuana. And there's, I think, an important distinction between the test that Special Agent Depew employed and then the Indiana cases that have been cited in the defendant's brief. In Indiana, the expert, who was just an investigator, said that she had no way of differentiating between hemp and marijuana. That's not what Agent Depew said here. She said that she was able to employ this test, which the TBI relies on to distinguish hemp from marijuana. It's based on the ratio of THC in the substance. After she performed that test, she then concluded that the ratio of THC was greater and that the substance was therefore presumptively marijuana. And so that is a sufficient building block to establish that the substance was indeed marijuana, and we get to the finish line with all of the attendant circumstances surrounding the discovery. It was 4:30 in the morning. The defendant was asleep behind the wheel of a running car. Lieutenant White immediately smelled the odor of marijuana when the window was rolled down. The defendant admitted to smoking weed. And then we have the way that it was stored. It was not in sort of a commercial packaging like one might expect hemp to be. It was in 4 bags, and there was also sandwich baggies and a set of digital scales and a large amount of cash, which Lieutenant White said was indicative of narcotics trafficking. So from that testimony, and then the testimony about the testing of the substance, that's enough to establish that the substance was marijuana. And again, Tennessee courts have never required a chemical test or a lab report to establish the identity of a substance. And I wanted to touch on a few things too about the cases Schutt and Siner that the state cited in its brief. Yes, Siner was decided before hemp was legalized, but what this court pointed out was that Special Agent Depew she testified that she couldn't differentiate between hemp and marijuana at the time, which this court said certainly weakened the state's case, but it didn't make the evidence insufficient. Another notable thing about Siner is, I believe my recollection of the case, there wasn't actually scientific testing that was performed. This was a visual identification of a substance, and then there was testimony from a police officer that the substance was marijuana. This court concluded, taking all of that together, the evidence was sufficient to establish that the defendant possessed marijuana. We have more than that here. And State versus Schutt similarly stands for the proposition that there is no chemical or lab report required before the state can conclusively establish that a substance is marijuana. And again, based on everything that the state presented here, it was sufficient to establish the identity of the substance. And then turning to the suppression issue, the name probable cause, as it suggests, deals in probabilities. It doesn't require absolute certainty. The state was not required to completely eliminate the possibility that this substance could have been hemp before having probable cause to search the vehicle. And as Your Honors pointed out, based on all of the information that was available to the officers at the time of the stop, the fact that the defendant was asleep behind the wheel of a running car, the admission to smoking weed, and then his mother's reference in the phone call to just tell the officers the truth about smoking weed, all of that gave the officers probable cause to search the defendant's vehicle. And for both the suppression issue and the sufficiency of the evidence, it seems like the argument is essentially the state has to exclude every hypothesis but that of guilt before either the evidence can be sufficient or there's probable cause to search, and that's not the standard. Our Supreme Court expressly rejected that in Durantes for analyzing the sufficiency of the evidence, and again, this court and our Supreme Court have repeatedly stated that probable cause does not require absolute certainty. And the information that was available to Lieutenant White and Officer McLean here was enough to satisfy that threshold to allow them to conduct the warrantless search of the defendant's vehicle. And unless there are any further questions, we would ask this court to affirm the judgment of the trial court. Thank you.
Your Honors, my friend made the point, which I believe is correct, that Tennessee law has never required a lab report to identify a substance. Tennessee law has also never in the past had a single plant that could be lawful or unlawful, with the only way to tell the difference is by measuring its concentration of THC. So we are in uncharted territory. That is reflected by the case law. There's no case law really either way. I acknowledge the cases we've discussed that do inform the court's guidance or inform the court's consideration of this issue, but none of them say what must be proved when you have a scientific requirement that is part of the definition of the controlled substance. And so for that reason, that is why the Indiana Court of Appeals went in the direction that it went. And it's why this court should give serious consideration to doing the same, especially when, again, the state's expert testimony was that the only testing done here was presumptive testing, which, again, based on TBI standards and the expert's own opinion, is insufficient to confirm beyond a reasonable doubt that the substance is, in fact, unlawful. I will say, just briefly on the Signer case, that I do believe that case involved visual identification, and the expert in that case said that there was no testing at that time that could differentiate between unlawful and, well, rather industrial hemp and marijuana. But at that time, it did not matter because all cannabis fell within the definition of the controlled substance known as marijuana. That is no longer the case. And so this is just fundamentally different from what we saw in Signer. And you have the exact same expert in this case who said in Signer that she could say with a high degree of certainty that it was a controlled substance. She said in this case that she could not confirm that. As a result, we ask that this court hold that the evidence was insufficient and the trial court erred by denying the motion to suppress. And for that reason, we ask that you vacate Mr. Jones' convictions.
Thank you, counsel. Anything further this morning? All right. Before we leave, Ms. Neff, you have the first case this afternoon. I don't know if the clerk's office has told you counsel is sick and has asked us to continue that till next month or some point in time. So we're going to grant that motion. So I'm letting you know so you don't feel like you have to sit around all afternoon if you do not want to.